how do you think so far that Carol's case is going? Case is now in. The closing arguments are now in. No defense presented by Trump's team. How well has she done?
I think it's gone about as well as it possibly could for the plaintiff. I mean, I think the fact that there was no defense at all, in order to find for the defense, you have to literally think that 11 different witnesses joined together in a conspiracy, and that's just not credible.
And the bigger problem, I think, Sarah, is even if you take out all the 11 witnesses, there are these 2 witnesses who testified in this case, both of whom say that she told them about it at the time, this woman Carol Martin being one of them. You kind of have to believe all 3 are lying, right?
Right, and outcry witnesses are very important. That's what you're referring to, is that very close in time to the incident, the victim of abuse actually made the disclosure. Because one of the things defense attorneys do is say, "Oh, why did you wait? Why did you wait so long?" Well, she didn't. She actually mentioned it. I think she was confused about whether it was an assault, but definitely stated the facts in a way that these women believe.
But Tacopina is saying that they're all lying, all 3 of them. He's basically saying this was political, that all 3 of them were in this together, and that's why he used that quote that I just mentioned up there, which he was suggesting was an effort to concoct a story, right?
You know, I'll tell you something. I was disappointed with the defense. I think that Carol had very defensible claims, both in terms of defamation and the rape. Obviously, part of it was because Trump boxed himself in by this flat-out denial. You couldn't say there was consent. You know, this lingerie thing in the dressing room, part of it was consensual, admittedly, and then he crossed the line. So they couldn't argue consent. They couldn't argue alibi. The look-back window law that passed in November 2022 really is disadvantage to the accused, because they cannot, it's plain and simple, he said, she said, they cannot get documents or witnesses 30 years later to defend themselves, and the statute of limitations is no longer a bar. The issue here is they should have at least put on a case. They should have had, much like in the Cosby case, in the civil part, which happened in Los Angeles, they had the victim or alleged victim examined by a forensic psychologist. They didn't even do that. So as a lawyer, as a defense lawyer, I can argue whatever the hell I want, but where's the evidence to back it up?
But Diana, I think that the strongest arguments for Donald Trump's team, right, are the ones that we hear from lawyers a lot, which is they still have to prove the case. Yes, it's a lower burden in a civil case. It's not proof beyond a reasonable doubt.
Right.
Just more likely than not, preponderance of the evidence.
Right.
But still, she has the burden to prove the case. And what Tacopina did in a number of instances, for example, this is number 24, he talked about her liking the show The Apprentice. She said, "I was a big fan of the show, very impressed by it. I'd never seen such a witty competition on TV, and it was about something worthwhile, competing." And she went on to make a joke on Facebook about having sex with Donald Trump in 2012, where she said, "Would you have sex with Donald Trump for $17,000, even if you could A, give the money to charity, B, close your eyes, and he's not allowed to speak?" And he then said, "So you joked around about it, et cetera." I mean, these are the sorts of things that her team is saying, we can explain it, et cetera. But if not all the jurors come to agree with her case, it's going to be things like that.
Sure, but I mean, what Tacopina is doing, and fairly skillfully, is stringing together, this is a pearl necklace of reasonable doubt, or sort of doubt about the case, right? Even that email that you cited in your opening remarks about Carol Martin saying this hasn't happened yet, and Tacopina, I believe, highlighted that in his summation. What's interesting about that is anyone who's paying attention knows that it's not hasn't is a present tense. It's not hadn't. In other words, it's very clear in the context of what that email was.
Hang on, but let's talk about the Facebook. I mean,
okay.
The email is something else. The Facebook post and her being a fan of The Apprentice, right? Those are things jurors can understand, right? It's not burdens. It's not legalese. It's just saying, wait, this guy raped you and you went and liked his TV show and you talked on Facebook.
Sure.
You joked about having sex with him.
Right, but jurors also have common sense, and jurors also understand that people process trauma in different ways. And in fact, I think that when you're dissecting that evidence in the jury room, you're thinking about, why would she come forward? Why would she put herself through what we know the Trump machine is capable of doing?
See, I think that's an easier response than the evidence itself.
Yeah, and also processing trauma. You know, I think the one good point the defense made is you don't even remember the date. I mean, this is Donald Trump assaulting you in this department store in this outlandish way. It's not like you're a child who's, you know, molested by an adult. You block it out of your memory. You've talked about it. You've told your friends about it. You actually went into the dressing room to try on lingerie. This is not, you know, some drug date rape kind of situation that you're so traumatized over that is blocked out. So those are really good points that, again, I think he could have had a consent defense, but he really messed that up for himself. And I think his defense lawyers also did an inadequate job.
Well, thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.